All right, everybody, please continue eating. There is plenty of food. If anybody wants anything extra, please help yourselves. As always, thank you to the Milwaukee Club for hosting this event and to their fine staff for always taking care of us. Good afternoon. My name is Lucas Vebber. I'm one of the vice presidents of the Milwaukee chapter of the Federalist Society. I'm going to be moderating the event today. I'd like to thank our friends at the American Constitution Society for co-hosting this event with us today. Before I introduce our panelists, I just want to be clear that this is not a political event. While the upcoming election will certainly have an impact on all of us, and especially the practice of law here in Wisconsin, this event is not a political event. Our panelists are here representing different viewpoints, but they are not surrogates who have been sent here to speak on behalf of a campaign, and so their words should not be attributed to any campaign or candidate for public office. Our guests today certainly need no introduction, but they will get one anyways. Professor Ed Fallone is an associate professor at Marquette University Law School, where he teaches constitutional law, immigration law, corporate criminal liability, and securities regulation, among other classes. Professor Fallone earned his undergraduate degree from Boston University, summa cum laude, in Spanish language and literature. He also earned his law degree from Boston University, magna cum laude. Professor Fallone has founded and grown 3 nonprofit organizations serving the underprivileged here in southeastern Wisconsin. He is a regular contributor to the Marquette University Law School faculty blog, and he also currently serves as the chair of the Milwaukee Police and Fire Commission. Welcome, Professor Fallone.
Thank you. Oh, stop it.
Our other panelist today is Daniel Suhr. Daniel serves as managing attorney at the Liberty Justice Center, where he spends every day on the front lines of the fight to preserve our rights and liberties. He represents parents and schools to advance freedom, education reform, citizens and nonprofit groups to protect privacy and free speech, and everyday people fighting back on behalf of cancel culture. And lately, he stopped several vaccine and mask mandates. Daniel formerly worked as a policy director for Governor Scott Walker, as chief of staff for Lieutenant Governor Rebecca Clayfish, and as a law clerk for Judge Diane Sykes of the 7th Circuit. He holds a BA and a JD from Marquette University and master's degrees from Georgetown and the University of Missouri. Welcome, Daniel.
Where I had great professors at Marquette Law School.
Oh, so sweet.
Yes, Daniel is a former student of Professor Fallone. So
I take all the credit for his success.
You should say that after the debate.
Okay, yeah, we'll see.
So here's the plan for today. We'll begin by giving each side a few minutes to make a brief opening statement regarding how the upcoming Supreme Court election will impact the practice of law in Wisconsin. I will then throw out a few questions. We'll alternate between which side answers first. I did use the Siri app on my iPhone to flip a coin, and Daniel will get the first question, or at least will give his introduction first. And then we'll allow for rebuttal and some back and forth as necessary. At the end, we'll ask each of our experts here to make a brief closing statement or just get out anything else they wanted to say that may have missed. And we will be taking questions from the audience as well throughout. So if you have anything that you'd like to ask, please start thinking those up. So with that, I will turn it over to Daniel for your opening remarks.
Great. Well, thanks everybody for being here. Obviously excited to do this. Thanks, Lucas, for getting my introduction right, that I work at the Liberty Justice Center. I have to tell you, I was on a radio show the other day, and I was introduced as Daniel from the Liberal Justice Center. So just in case you're wondering which side of this debate I'm on, actually, I was on a different radio show and is introduced as Daniel from the Liberty Justice League, which is what made me sound way more like a superhero to be part of the Justice League. So I think it would be useful to start by defining the job of a judge. And for that, I have the following quotation. Judges can't rely on what's in their heart. They don't determine the law. Congress makes the law. The job of a judge is to apply the law. And so it's not the heart that compels conclusions in cases, it is the law. The judge applies the law to the facts before that judge. That incredibly textualist, originalist, anti-values statement was made by Judge Sonia Sotomayor when she was nominated to the Supreme Court in her confirmation hearing. She had been asked by Senator Lindsey Graham about a statement that then Senator Obama had made when he was discussing his vote on Justice Alito's nomination. And at the time, Senator Obama had said, well, I think the critical ingredient at a judge at the end of the day is what's in the judge's heart and whether or not they can empathize with a person who comes from a minority religion, from a minority racial background, from a minority sexual preference, and if you have the empathy to understand that person as you consider their case. And so Senator Graham read that to Judge Sotomayor, and Judge Sotomayor rejected that framework and instead said, no, judges can't rely on what's in their heart. Obviously, I draw that through to today because a lot of what we've heard in the course of the last few months is about values and whether or not a judge's values should affect their job, or whether or not I hold certain values, but I would never apply them on the bench, right? I want to tell you what my values are, but there's just background information. I won't actually use those. I'll just follow the law, right? Which sort of prompts a question like, why are you telling us your values in the first place if they're not going to influence your decisions, right? You're not telling me the first names of all your children because it's not going to influence your decisions. You don't tell me plenty of other things about your life, what your favorite movie is, because it's not going to influence how you do the job of a judge. So why are you telling me what your values are if you swear that it's not going to influence your job as a judge? So that is my first big thought, is that the values that judges hold really aren't appropriate beyond some very basic things like integrity and impartiality, and that when judges communicate their values to the voting public, what they're really doing is signaling their political and personal preferences, and that's not appropriate. The second big observation I want to make in terms of whether or not this case will have major implications for the practice of law in Wisconsin, or this election rather, I think a lot will just come down to, if she wins, Judge Protasiewicz's approach to precedent. A lot of what we've heard talked about in this election is major topics that the court has settled in the past. And there are many times in the past where membership on the court has changed, and yet new judges are then confronted with this question, will we change precedent? So I have turned to, again, a case called State versus Lynch from 2016. The doctrine of stare decisis requires fidelity to the rule of law. Schiffer is well-established precedent, the case at issue in there. And the question is, should we overturn it? The answer is clear. We should not. Nothing of legal consequence has changed since Schiffer was decided. The only change has been in the composition of this court. That was Justice Ann Walsh Bradley dissenting in 2016. The oral I'll give you is from Justice Ann Walsh Bradley and Justice Shirley Abrahamson, Chief Justice Abrahamson. This is State versus Lindell in 2001. I'm sorry, this is actually just Ann Walsh Bradley. I now briefly address the majority's decision to overrule Ramos. I happen to be among those who believe Ramos was wrongly decided. I joined the dissent in Ramos. I later continued to dissent in State versus Farron several years later. But despite my disagreement, this court has consistently affirmed Ramos, and I've acknowledged it as valid precedent. Until today, Ramos has remained valid precedent. Out of respect for the court and the law, I believe the majority should continue to acknowledge it as precedent. Nothing has changed but the bodies on this court, and yet the majority overrules a case that, to my recollection, has been reaffirmed more than any other case in the last 4 years. So when we think about topics like redistricting and abortion and Act 10 and right to work and all the other topics that have been thrown out as potentially vulnerable because of this election, they are only vulnerable based on the approach to precedent that Judge Protasiewicz, were she to win, and Justice Karofsky and Justice Dallett, who are new to the court since those cases were decided, like how they approach precedent. And will they believe in stare decisis? Will they be willing to accept decisions that they may personally have decided differently? Were they on the court at the time, but that they recognize are valid and binding today? Or are they on a campaign to overturn precedent and fundamentally change things because they think that they should realign with what the correct decision should have been in their view? And will Justice Ann Walsh Bradley, who, as I just read to you, I think has a very strong view of precedent, change that view when she's given the opportunity to do things like overturn the redistricting decision or overturn Act 10? Those are my two big thoughts.
Thank you, Daniel. Professor Fallone.
Daniel, my problem with the name of the Liberty Justice Institute is grammatical. It should be the Liberty and Justice Institute. Thanks to ACS, the American Constitution Society. Thank you to the Federalist Society for the invite. Thanks to all of you for being here. Is anyone here happy with the way we select our Supreme Court justices? I think that's something we can have unanimous approval that we disapprove of the way we select our Supreme Court justices. When I joined the faculty at Marquette University Law School in 1992, the first Wisconsin Supreme Court justice I met was Justice Nate Heffernan. And he was giving a talk that I attended on a defense of judicial elections. And he gave the judicial election process a hearty Jacksonian democracy defense in its origins. And I was a skeptic. I came from the East Coast to Wisconsin and from the state that had appointment of Supreme Court justices for the state. And so I was skeptical of this strange electoral process, but you know what? He convinced me. And then I ran for the state Supreme Court twice, and most of you will have forgotten because I lost twice. But I became a defender of electing judges through that process because what I learned is I had to go around the state. I had to go to dairy farms, out to the west of Green Bay. I had to go to La Crosse. I had to go to Wausau, and I had to meet with people, and I had to talk to people about how is the law affecting your life? How can we make the law make your life better as opposed to make your life worse? And I learned so much. I thought it was great that people who are going to sit on our state Supreme Court have to get out of their bubble and go around and talk to folks all over the state who have wildly different experiences. And I thought, electing judges is good. But it should also not just be a benefit to the candidate. The electoral process should be a benefit to the voters. They should learn through elections what the candidates stand for, right? They should have some basis on which to cast a ballot, right? Why have an election if people have no idea how to vote, why to vote? And what we have today, as we all know, is a system where 90% of the ads are television and negative because they work. They don't present positive reasons, affirmative reasons to support a candidate. They simply tear down the opponent. We have partisan wolf whistles or signals to bring out the partisan vote because turnout is more important, and generating excitement among your partisan base is more closely connected to victory than rationally making your case to the voters. And so we have partisan negative advertising. And that's the way our campaigns are run. We assume in an election, voters will be educated. They will cast a ballot on the basis of which candidate furthers their values, their belief system, they think is better qualified, reputational basis. In the law, the average voter has no clue what judges do. They don't understand the difference between one judge or another. And if we are not educating them as candidates, then they're left with nothing. And now, to run for office now, you don't even need the voters. All you need is one or two very wealthy donors, and they'll fund your TV ad campaign. You just need to talk to your little partisan bubble, and they'll generate turnout. You rely on the money that comes from a big donor. You rely on the infrastructure, right? The campaign staff, the mailing list, the infrastructure that you get from your political party. And there's no need for the candidates to interact with the public. And that's what we have. I used to think public funding of judicial elections was the answer. Let's have public dollars so candidates don't need to raise money themselves. But now I think even if we had public funding, it would just be overwhelmed by the big money donors and the political parties. And I think this is important to all of us as officers of the state, members of the bar, because I think what we need is more Supreme Court justices like Brian Hagedorn. Now here's a justice that my ACS friends hate and my Federalist Society friends hate. No one can love Brian Hagedorn except for me. Because to me, he is the epitome of judicial restraint. Now, I know judicial restraint is not popular. I know it's not popular because I ran on a platform of judicial restraint in 2020 and I got 13% of the vote. That is not the path to victory. We need justices who will read statutes in a way that is only necessary to decide the case in front of them and no further. We need justices who will reach constitutional questions only when it's necessary to decide the case in front of them. And when they do have to interpret the Constitution, we need justices who respect precedent and who do not use the opportunity of constitutional interpretation as a chance to conduct a one-person constitutional convention. My colleague at Marquette, Chad Oldfather, has said that we have some justices on our current state Supreme Court who have a castle-in-the-sky vision of how state government and federal government should be structured and organized and run. And they view each case in front of them as an opportunity to drop pieces of that castle-in-the-sky vision into precedent, to eventually create a real-life version of their castle in the sky, instead of doing what they should be doing. Focus on deciding the case in front of them. Don't focus on your castle-in-the-sky vision. Thank you very much.
All right, thank you both for those introductions. Let's get started. I think the first question we'll direct at Professor Fallone, since Daniel started with the introductions. Building off what you said on interpretation of statutes, State Ex Rel. Kalal versus Circuit Court for Dane County has served as the basis for statutory interpretation in Wisconsin courts for almost 2 decades. I think it is probably the most cited case in Wisconsin history, or certainly up there on the list. I don't know for sure. I didn't look at the numbers. Probably should have. But a new majority on the Supreme Court could have some profound impacts on the interpretation of statutory text here in Wisconsin. This is admittedly a broad question, but what impact could a new majority potentially have on statutory interpretation here in Wisconsin?
Well, we're talking about a judicial election that could, depending on how Justice Hagedorn votes in a particular case, could swing control of the court 4-3 one way or the other. And I think it would be a moving majority, not a permanent. And I think, really, if I have any advice for all of you in your practice, start figuring out ways to convince Hagedorn, right? That's going to be the key, if you haven't already. I don't foresee a rethinking of theories of statutory interpretation. I think it's all in the application, and I think that is the problem. There's general agreement that the job of the court is to try and effectuate the intent of the legislature, but the question is whether you're just mouthing that as your purpose, while at the same time selectively picking out words in the text in order to arrive at your own preferred outcome. I think in general, I was going to say, trying to shift something I was going to say about a different topic to this topic. I don't think it's working. I think, for example, on the question of separation of powers, if I could, it's not a direct parallel to the question, but I'll give it as an example. We have the major question doctrine that the U.S. Supreme Court is toying with in regards to whether a particular congressional statute delegated broad authority to an agency. And the U.S. Supreme Court toying with adopting the rule that if they're going to interpret a statute to be an expansive delegation of authority in a major question, major issue, there should be express provisions in the statute indicating that intent. So we're still talking about how do you determine intent of the drafter of the statute. But I think that's a fake enterprise, because it makes no sense to take a statute written in the 1940s, 1950s, 1960s, and say, oh, this should have had an express language indicating intent that the agency should be able to handle this major question. It makes no sense to take a statute drafted 80 years ago and impose a requirement on that legislature to have known the magic words they should have included. I mean, maybe prospectively saying, in the future, we will interpret statutes in this way as a way of divining intent makes sense. But to create new standards and impose them retroactively and claim you're divining intent for laws written 80 years ago when they had no idea that this was going to be necessary, it seems to me that that's a false effort to find intent. So hopefully that doesn't go too far afield of the question.
Oh, Daniel.
So the good news from my perspective is that in Justice Kagan's words, we are all textualists now.
No.
Right? Like, I think just fundamental expectation.
She said originalists, not
Okay.
textualists.
Well, we are all originalists now. Somebody has said we are all textualists now. I think the point remains. So on the one hand, there's a difference between methodological precedent and substantive holdings, I think, right? So if you look at the U.S. Supreme Court, right, you might have a 5-vote majority in opinion that Justice Scalia writes where he says legislative history is terrible. And, 6 weeks later, you get another majority opinion from the court, and it's written by Justice Breyer, and there's legislative history throughout. And then there's just a little footnote at the top that says, this is a unanimous opinion, and Justice Scalia joins everything except for paragraphs 47 and 48, where he does the legislative history thing, right? Obviously, Justice Breyer did not feel bound as a matter of precedent by Justice Scalia's previous opinion saying legislative history is bad. So on the one hand, I don't think if you had any justice on the court that they would necessarily feel bound by Kalal to do statutory interpretation a certain way. Maybe that's different if you're at the Court of Appeals, that the Court of Appeals might feel bound, or at the circuit court level, by a methodological precedent, but I don't think on the Supreme Court that's necessarily true. All of that said, in Kalal itself, interestingly, Justice Abrahamson dissented, Justice Bradley concurred, and basically threw up her hands and said, I join neither discussion. I'm not all in on legislative history. I'm also not all in on Diane Sykes' textualism opinion. I'm out. And so I wouldn't presume that Justice Ann Walsh Bradley or Justices Karofsky or Dallett or Judge Protasiewicz would necessarily mark a substantial shift. I think a lot of these battles have been fought. Many of them we've kind of reached a consensus as a profession, and I don't know that we're going to be revisiting those conclusions anytime soon.
I concur with paragraphs 1 through 10 of Daniel's statement and dissent from 10 through 15.
Yeah, that's about right.
All right. Question 2, and question 2 will go to Daniel, keeping in our alternating order here. Along the lines of what you were saying in your introduction and kind of what you were just talking about now, it would certainly seem likely that a new majority on the court could revisit some holdings of the old court, including recent holdings. This election will have a profound impact on stare decisis, the role of precedent. You touched on some of this. I'm not asking you to repeat yourself, but what should the role of precedent be? And can you discuss your views on how this election could impact the value of precedent going forward if we do see a lot of tipping over the apple cart, so to speak?
Yeah, so I think this is most interesting in the discussion of redistricting, that we have seen a lot of talk in the election so far about fair maps, and that one of our values should be fair maps. And again, when we talk about our values, we're not necessarily saying that should influence our decisions, but it seems like we're going to talk about fair maps, and that there's going to be a case filed relatively immediately asking the court to overturn the existing legislative and presumably congressional maps. And the problem is the court has recently upheld the existing maps. It was, as everything, I think everybody in the room knows, right? We didn't have a legislative agreement with the governor, and so and we didn't have a federal court imposed maps. It was this court that gave us these maps, and that process was both very legal in sort of a very technical sense of how are we going to draw these maps, and there were also a lot of big picture constitutional questions and Federal Voting Rights Act questions and other things that played into how are we going to get these maps, and so a lot of the questions were answered in that process. So I think it's going to be hard to say, well, we are now raising new questions that weren't presented in that original proceeding in this challenge that we're filing to these maps. And so I think it will come down to a question of how certain justices who frankly haven't given us an announced view of precedent end up viewing precedent. Like I don't know that Justice Dallard or Justice Karofsky or Judge Protasiewicz has given a thoughtful explanation at some point of their view of precedent. I think the real interesting question will be for Justice Ann Walsh Bradley, that she has given a thoughtful explanation of her view of precedent. It has been a very strong and deferential view of precedent. The cases that I read earlier are 2 of a dozen I could cite you, where she has defended precedent, even precedent she originally dissented from. And like it's going to be a very, I think, interesting and difficult question for her to reconcile that with a lawsuit that could be coming very soon.
Thank you. Professor Fallone?
I think, as Daniel knows from his day job, yes, there's precedent, but it all depends on what the question you ask is.
Right.
And the Wisconsin Constitution has an express right to vote, right? Every citizen who resides in the state of Wisconsin is an elector. That's a grant of a right to vote in express terms. It's not in the U.S. Constitution. So take all our federal right to vote precedent and push it aside, because there's no express right to vote in the federal Constitution. But Wisconsin, it says, black and white, you're an elector, you have the right to vote. Well, I think there's still a lot of room to ask, what does that mean, that right under the Wisconsin Constitution? And look, friends, we're told constantly, there's no such thing as a second-class express right. There's no such thing as an express right that gets treated less deferentially, less important than other express rights. That's what supporters of a broad interpretation of the Second Amendment have been saying. Well, the right to vote is an express right in the Wisconsin Constitution. It should not be treated as a second-class right. Now, what does it mean to have a right to vote? Does that mean you cast your ballot and then the official, my friend Mark Thompson, takes it, crumples it up, throws it in the trash? Technically, you voted. Well, no, obviously, you have a right to have your vote counted. And what about if you combine the express right to vote to the express right in our state constitution of equal protection? Isn't that the right to have your vote counted equally to everyone else? Now, these are questions Wisconsin Supreme Court has not been asked. They haven't had to, right? Because you could always rely on the federal courts, federal precedent to protect the right to vote, the Federal Voting Rights Act. But as all of that federal protection has been dismantled, and now the United States Supreme Court has said, oh, no, this is just a question of state constitutional law, we have a vacuum here. And all it takes is the right questions to be asked. I think if, this is a hypothetical, if 40% of the voters of Wisconsin have been electing 60% of the members of the state legislature, I think there's a question. What does it mean to have the right to vote if it counts less? Shouldn't we have something that approximates more equality in the weight of voting, and that means looking at districts? This doesn't mean the Supreme Court of Wisconsin should adopt specific districts. They simply have to look and say, well, these districts result in a 40-60, come back with something better. We strike these down. We're not going to draft it for you. And if the legislature refuses to come back with something better, then, okay, the two parties submit their districts. We have a special master, has to choose one of the two. Gives every incentive to both sides to try and come up with something that is not too extreme for their side, because you want the master to pick yours, and you get something adopted through that process. But I don't see any reason why the state Supreme Court, if the right questions are asked, cannot interpret what it means to be an elector under the words of our Constitution.
So if I can just add to that quick, I think there's a broader thought about the role of new federalism in the court. That maybe last time we had a major conversation in our state around our Supreme Court, I'm thinking about like the 2008 Gableman election. One of the major themes of that election was this question of new federalism. When is it appropriate for the state Supreme Court to depart from what the U.S. Supreme Court has said and interpret our state constitution differently than the federal Constitution has been read? And I think that directly plays into this discussion of redistricting, because the U.S. Supreme Court may have said it's not a justiciable question, how maps are drawn, or whether or not partisan influence being too great at some point, or whether or not the equality theory of weighting these different things and having professors come in and produce these kind of studies. Like the U.S. Supreme Court last term, 2 terms ago, kind of said we're not going to get into that business. But you're quite right. There's no reason the Wisconsin Supreme Court can't. I think there's been a general, again, methodological line drawn that says, by and large, we're going to defer to the U.S. Supreme Court, but there's no reason they have to.
And I would say that it's important that where there has been deference to the federal interpretation when interpreting the state constitution, that has greatest weight as an argument when it's the same words, like equal protection at the federal level, and how should we interpret equal protection at the state level. But when you don't have the same words, there is no elector at the federal level. I think that leaves it much more open for the states to act independently.
And I would say the same thing about the Religious Liberty Clause in Wisconsin being broader than the Federal Free Exercise Clause.
I'm just going to say stop agreeing with me.
It's a debate, girl, darn it.
Damn it.
Very good back and forth. Some very good back and forth. Moving on to a new topic, enforcement of the separation of powers. And this will be directed at Professor Fallone. You mentioned it in your intro briefly as well. Separation of powers has been really a cornerstone of many opinions from the court in recent years, from the Tetra Tech decision on agency deference to Legislature versus Palm regarding agency orders and administrative rulemaking. The court has sought to enforce the structural limitations on government. How could this election transform the court's separation of powers jurisprudence? What does that mean for the practice law in Wisconsin?
It's a good question. I'm going to respond in an originalist fashion. It's too easy to. The U.S. Supreme Court has been on sort of a mission to rethink separation of powers, to reconceptualize what that means, the division of authority between legislative, executive, and judicial as sort of a principled theoretical matter, questions of delegation of lawmaking power to agencies, et cetera. We should be careful about simply grabbing these discussions of general principle from the federal courts and the U.S. Supreme Court and importing them into the Wisconsin Constitution, because the Wisconsin Constitution is different, right? I mean, on the first hand, any state exercises the police power. The federal government has no police power. The federal government just has power delegated to it, and that has implications for how that delegated power might get divvied up. Well, the Wisconsin Constitution, any state has the police power, the general power to protect the health and safety of the residents of that state. That is much broader than a delegated power. And so the division of that police power, the division of this broader power may be different. And there may be, for example, more of a role for the executive to implement the police power than there is for the president to implement the delegated powers of the federal government. Another important factor under the state constitution, of course, is we have more of a division of authority within the executive branch. The executive branch at the state level is kind of a multi-headed hydra. We directly elect more positions in the executive branch than just the governor. And that has implications for separation of powers, because we're not talking about just separating power between the legislative branch and the executive headed by a governor. We're talking about separating power between the legislative branch, the governor, the constitutional officer of Secretary of State, constitutional officer of Treasurer, Attorney General, etc. And so just simply importing the U.S. Supreme Court's latest pronouncements about separation of powers and say, well, we've got to treat it the same way in Wisconsin, is ignoring the textual fundamental differences between the Wisconsin Constitution and the U.S. Constitution. What does this mean? What's going to happen? All I'm saying is, if indeed we have originalist justices who engage in true originalism, not just randomly plucking out words from the text in order to reach a predetermined result, so-called faux originalism, as how Judge Posner referred to the Heller decision and Justice Scalia's reasoning in Heller as faux originalism, F-A-U-X, like faux fur, right? If you're really going to be an originalist and really engage in the hard work of trying to understand the differences between the Wisconsin Constitution and the way government power at the state level is separated from the federal, then there's a lot of open field. And I don't know, it's not necessary for the justices on the court to go one direction or the other, but I'm just saying there's a lot of open field if you're a true originalist.
Daniel?
So let me defend Justice Rebecca Bradley's Castle in the Sky, and kind of explain how I think about separation of powers. So I agree with Professor Fallone that obviously the state government is different in some respects, but in the most fundamental way, I think it's not, and it is that there are vesting clauses in the state constitution, right? Fundamentally, as a textual matter, the U.S. Supreme Court's recent development of this doctrine has been based on the vesting clauses. And so we vest the legislative power in Congress, we vest the executive power in the presidency, we vest the judicial power in the judiciary, and those clauses also exist at the state level. And so when the executive, when a state agency writes a rule, like the question is that wielding legislative power? And has that legislative power been vested in the state legislature? And was it appropriately given away to another branch? So we may have a plural executive. I certainly agree that there's actually a very specific vesting clause for the Department of Public Instruction, for the Superintendent of Public Instruction. And there have been several cases about like what is vested by that vesting clause. But fundamentally, I think the separation of powers really comes back to those vesting clauses. It's a way in which, for instance, like county government is different. Will had an interesting case last year about whether or not non-delegation can happen at the county level. And one of the things that's like awkward about doing it at the county level is like we just have a county board, right? There's just a legislature. There's not necessarily a judicial or executive branch at the county level. The other quick thing I would say in defense of the Castle in the Sky is that fundamentally I think the Wisconsin framers had the same interests as the U.S. framers, and that is the separation of powers protects liberty. That the key insight of the founding generation that made it different from everything that had gone before was not only that we had a written constitution, but that written constitution divided power between the branches, and that the branches would check one another and be zealous to guard their power against one another. And that is what protects our liberties, right? Justice Scalia always used to say, the USSR has a longer, more detailed Bill of Rights than the American Bill of Rights. But it doesn't matter if the KGB can haul you out of your house in the middle of the night. Because there's no independent judiciary to check them. There's no independent legislature to hold an oversight hearing, right? There's no accountability.
If I could, I first want to agree with Daniel about the wisdom of the Becker versus Dane County case, where the Wisconsin Supreme Court rejected an attempt to apply separation of powers at the county level. A very good opinion written by Justice Hagedorn. And I would just ask Daniel, the vesting of legislative power in the state legislature is important, but how do you account for the partial veto where the governor is given the constitutional power to change the law?
Yeah, it's a great question. I don't know that I have a good answer, right? I think the president has always exercised some level of involvement in the legislative process. Frankly, the vice president has always had some level of involvement in his role as president of the Senate. And so I don't see it as incompatible that our founders gave the governor more involvement than the president did. Like there's always been some sharing in that sense.
Okay.
All right. Are there any questions from the audience, preferably not related to cases that Will has lost at the state?
We don't have time.
I think I found the amicus brief supporting Will and Becker, actually.
But any questions from the audience at this time? I just want to open it up. If anybody has it, we've got a little bit of time left. Yeah.
So, thank you. So, Professor Fallone, I guess I'm trying to follow the logic, but so if you look at, for example, the Attorney General, right? So the Attorney General of Wisconsin, independently elected, his or her powers are clearly statutorily defined as well. Mm-hmm. So, I guess I'm trying to, you made the argument that we have a different executive branch versus the federal level, but it's not as though the powers of these other executive officers, so the AG, Secretary of State, Treasurer, DPI secretary, those are still defined. So it's not as though they have unlimited police powers themselves. And so, when you're looking in terms of separation of power, you can literally look in statute section to define, okay, what can the AG do or not do? He or she does not have an unlimited police power. So is it really all that different from the federal government, where you just have a unitary executive, obviously the president appoints the position?
Well, I don't have, a thought out proposal to explain how separation of powers should be divided up under the Wisconsin Constitution. I think my point is simply our Constitution as a state is very different than the federal. And so merely grabbing some language from Supreme Court decisions about separation of powers and applying it to the Wisconsin Constitution, because you might, as a justice, share the sort of general desire to sharply cabin, legislative power in the legislature, et cetera. And maybe you share this idea that executive agencies should not have broad discretion to create rules. Well, simply grabbing that language from federal precedent and importing it to the Wisconsin Constitution because you share the same political philosophy doesn't work if you're really an originalist, because our Constitution is different. And these differences have to be accounted for. Now, maybe you can account for these differences, the partial veto as express grant of power to the governor to participate in the actual making of a law. Maybe you can account for that and still say all lawmaking is vested in the legislature. Daniel will come up with some smart argument. But I'm just saying you have to engage in that. That's really my point, is you can't just wholesale grab that language and apply it without recognizing the difference.
So one of the things I think is interesting in the state constitution is that the DPI has a very specific vesting clause. The Secretary of State has a specific vesting clause in terms of particular responsibilities, like keeping the seal. There's a really fascinating case that I'd point you to if you want to dig into this from probably 15 years ago now, Cocken versus ASME. Cocken was the sheriff of Brown County, and the county board wanted to do something to the jail. It was like the menu of food that was going to be in the jail, or like the hours that the sheriff's deputies could work in the jail, something like that. And the sheriff was like, no, god darn it, the jail is my job. I run the jail. I'm elected to run the jail. I'm the sheriff of this dang county. It's my jail. And if I want to, serve them poor food, or if I want to hire whomever as my deputies, right, it was a negotiation with ASME. ASME was challenging his way of running the jail. I can do it. And so it goes to the state Supreme Court on this question. All it says in the Constitution is the people shall elect sheriffs at the county level. Mm-hmm. And basically, could a county board turn a sheriff into the state treasurer? Could they just strip it down to the bolts? Mm-hmm. And the court said, no, we're actually going to go through this interesting kind of historical analysis of what sheriffs did in the English history, and what sheriffs did in the early American history, and what sheriffs did at the founding of Wisconsin. And we're going to deduce from that, sheriffs get to run the jail. And that's how they resolve the case. So for this plural executive concept, I think the important thing is to look at what does the Constitution actually vest? And in the case of DPI, there's a lot of power there. In the case of the Attorney General, there's really not much, right? It just basically says whatever the statutes delegate to the AG, that's what the AG will do. The question of could you strip the AG down to the bolts like we did with the Secretary of State or the State Treasurer? I think actually Cocken would be the kind of on-point example. There's your little tour through English history.
Are there any other questions? Otherwise, we're probably running out of time. I'll ask the candidate, or the candidates, our guests here today, to give some.
Remember to vote for me April 4.
Slip of the tongue. Yes.
Really, for Daniel, you mentioned personal values and the phenomenon of the candidate saying, here are my personal values, maybe as a way of implying that they're going to vote in favor of those personal values. How is that different, if it is, from, say, candidates who appear with law enforcement in their act? Both candidates have done so. Justice Abrahamson, I remember doing so in her last election. Would you say that also implies that they're going to render decisions in favor of law enforcement, and is it inappropriate in the same way as the
Yeah, it's a great question. So, and I'll admit a certain level of conflict on this internally. Like, I'm not entirely sure the SCRs are entirely constitutional on this, right? Like, Republican Party of Minnesota versus White was brought by the Republican Party and authored by Justice Scalia, where he strikes down, part of Minnesota's SCRs, limiting what candidates can say while they're running in judicial elections. Conversely, then the Supreme Court comes along a few years ago, and I think it's like Yulee versus State Bar of Florida, and it's like, I really kind of forget that, right? Like, maybe we didn't mean everything we said in Republican Party White. So I do think there's got to be a strong protection for judges to, like, judges get First Amendment rights like everybody else, especially when they're candidates. And so I wouldn't render an opinion today about whether or not Judge Protasiewicz has crossed some sort of line in terms of what a successful judicial commission complaint would be. All I would say is Judge Protasiewicz has gone further than I think any candidate in modern Wisconsin history in naming particular issues and aligning those with her values. That even the way,
You don't get to say anything, Mark. You might have to rule on this. You should recuse yourself.
Yeah, I guess maybe I'm wrong, but like, I don't remember a point at which like Justice Karofsky or Justice Dallett was talking about fair maps and reproductive rights. Maybe their allies were, but I don't think the words ever came out of their mouths in the same way.
Values is different than particular legal theories or results. Right. I mean, you could say you support a woman's right to choose. In the absence of Casey and whole woman's health as precedent, I'm not going to say Roe versus Wade because that wasn't the precedent. Yeah. In the absence of Casey and its following cases as precedent, saying you support a woman's right to choose does not necessarily mean you say you want Roe back, you want Casey back. There's a wide variety of potential rulings. For example, North Dakota, South Carolina, if I'm recalling correctly, are the two state Supreme Courts that said, look, if you have no exception for the life of the woman, that violates our state constitutional guarantee not to be deprived of your life. I mean, we're not talking substantive due process. We're talking about the state forcing you into a very likely fatal situation. And so just saying you support a woman's right to choose does not mean, I want Roe versus Wade back, I want Casey back. It simply means there's a lot of options out there, and I don't think that that is unethical under current standards, and I don't think that that's improper.
All right, question mark?
I just want to throw out there, when you talk about precedent, when you have people going on 50 years, I started my legal career at the Seventh Circuit working for Judge Coffey. Yeah. One of my assignments was helping on a dissent on the abortion questions, and it was 15 years old at the time, right? So, but how a precedent and a practice impacts people for 50 years, we're going to see how it plays out at the ballot box. I think that's what's unusual about this race. You took this, lawyer, we know cases, or we think we know cases, and some of us know a lot more cases than me, but this idea of a woman's right to control the reproductive health existence, it's never been teed up like that in Wisconsin. Yeah. So, because in terms of when you say what precedents are you going to follow, yep. Right? I think the people see that 50 years of what their existence was. It's like, why isn't that the way to follow? So, and the presidential on the redistricting is a little different and not quite as well known, right? But on the merits, the court that decided the constitutionality of the redistricting on the merits said that it wasn't fair. It wasn't fair, right? I mean, that's a federal judge. I mean, we had a Republican, we had a Democrat, 2-to-1 split. Right, when Roberts punted on the whole issue, they never touched the merits. So from a merit point of view, the precedent is that the maps are unfair.
So I think the comment I'll make is I will encourage Professor Fallone to submit his supertextualist amicus brief in the forthcoming abortion decision, because one of the things that's interesting, if you look at the text of the Wisconsin Constitution, right, we don't actually have the exact word for word 14th Amendment text that creates a substantive due process right. We have Article 1, Section 1, which is worded similarly but also somewhat differently. And I think most importantly, unlike, say, Illinois, like Illinois wrote its constitution in the 1970s and included a right to privacy explicitly in the state constitution. And there's, legislative history from the Constitutional Convention about whether or not that covers the right to abortion. But there's no similar textual hook creating a right to privacy in the Wisconsin Constitution.
I'm not basing it on right to privacy. I'm saying the government cannot force me to engage in an inherently dangerous act against my will. And that's not to do with substantive due process. That's my guarantee that my life can't be taken away without due process. That's not substantive due process. It's the same as, government can't force me to walk into a cage filled with wild lions against my will. I don't think that's substantive due process.
Okay,
Well, thank you both for this wonderful back and forth. As we are running out of time, before I give you each the last word, and we'll start with Daniel, but I just want to say thank you to everyone for attending today. Thank you to the American Constitution Society for hosting this event with us today. Milwaukee Federal Society will be back here on April 18th for an event, Originalism, Precedent, and the Wisconsin Constitution, with attorney Steve Biskupik. Right here, you can register on our website, mkefedsoc.com, and please join us for our statewide conference on May 5th as well. With that said, I believe Daniel is up next in the alternating order, so I'll let you say closing remarks very briefly, please.
Yeah, so judges are not robots. They're not interchangeable. When we go to the ballot box to make a choice as who our judges are, we shouldn't be asking who got the best GPA in law school. We should be asking who's going to do the job of judge correctly, who approaches the job in the right way. And I think the case I've been trying to make today is that the right way to do the job of a judge is to be faithful to the text and the original meaning, to be informed by precedent, and to be restrained and humble in the way you go about doing it.
Yeah, and my only pushback is, I think there's a tendency by some on one side of the political divide to simply assume, oh, the other side hates originalism and we love originalism and that's all there is to it. Well, no, I think I love good originalism. I hate bad originalism. I hate pretextual fake originalism. And there's too much of that going on. And I agree with Daniel. We need to have judges who know how to do a good job of determining the original intent. And unfortunately, we have a system of electing judges and the reality of electing judges that does not guarantee we get those kinds of judges. And we should, as a profession, think long and hard about what we can do to fix that. Thank you very much for being here.
Thank you both.
Hey, thanks for doing it.
It's fun.
And that concludes our event today. Thank you, everybody.